national security firm. So that's the whole gamut of our practice: imports, exports, sanctions, and then defense contracts, NISPOM items, and then as well as CFIUS, like you already heard from Veronica. So I will say enough on that and get going. So a quick agenda. I'm going to cover a lot in the next 35 minutes, and I want to leave some time before 12:45 for the question section. I'll really briefly go over the agencies, looking at who's registered and job titles. Most of you are going to be fairly familiar with the agencies. We'll talk about knowing your customer, screening, which is obviously a huge part of due diligence. A bit on enforcement, a couple of cases I'll quickly go through, and then just how all this fits into a larger compliance program and screening program, and then tips that I've just drawn from my experience. Some of that will be reiterating things I've already said, but to get going, the agencies, like I said, most of you should already be familiar. The Department of Commerce, Bureau of Industry and Security, administers the EAR, which is generally dual-use commodities, software, and technology. But since export control reform over the past few years, or several years at this point, there's a good chunk of military, strictly military items that are controlled under the EAR, which complicates things for some of our clients. It used to be a more simple breakdown, but now jurisdiction plays a lot larger role. Speaking of jurisdiction, there's also the Department of State, Directorate of Defense Trade Controls. That's controlling defense articles, services, and related technical data under the ITAR, International Traffic in Arms Regulations. And then finally, the Sanctions Regulatory Agency is under the Department of Treasury. That's Office of Foreign Assets Control. I'll be calling it OFAC for the rest of the presentation. So red flags, these are published by BIS, and they have been for years now, but a lot of these scenarios are going to be pretty similar to what you would find regardless of the agency. In other presentations, we'll discuss red flags, we'll discuss due diligence, but I usually don't have a chance to talk about them in any detail. So I did want to take the first couple of slides and just go through a few of these and not only talk about the scenarios, but when I look at these scenarios, I think about, okay, what part of a compliance program would help address these scenarios, and then really thinking as an attorney, in case there is a violation that comes about based on a similar situation in a voluntary disclosure, if that's the route that the client decides to go, what sort of corrective actions would the government want to see to address this and prevent it from happening again in the future? So the first red flag is the customer or its address is similar to one of the parties found on a government list of denied persons. So in this scenario, half the battle's done. It looks like there was screening, but then what happens after the screening? How similar is the customer or address? How likely are they to actually be a match? And so what's involved there is, if the screening's already done, it's the training of the individual that's going to be looking at the screening results. And there's actually an enforcement case we'll talk about here briefly that that addresses that more directly. Next red flag, the customer or purchasing agent is reluctant to offer information about the end use of the item. So this is where there is in-use statement is best practice to get these for most your exports, especially if they're controlled items. And what I've seen with clients is in some situations they have a great tool. It's a great in-use statement document, but then when it's filled out by the customer or the purchaser, there's missing information, and then sales staff or whoever is communicating with the customer does not follow up. So then you have this really useful document, but you're not really using it and getting the most out of it. So if they're reluctant to offer information about the end use of the item, will you ask again? And if they continue to be vague or evasive, well, that's when other questions come up and further due diligence is required. The next one, the product's capabilities do not fit the buyer's line of business. This is BIS's example. such as an order for sophisticated computers for a small bakery. So it's not always going to be that straightforward, but to address these situations, one, your frontline people need to understand your product. They need to understand the capabilities of your product so that they'll understand if whichever end user is listed fits that line of business that would use your product. So for that, you need to know your customer as well as the end use statements. And sometimes it requires training of your frontline staff and just knowing about your product and where it's going. Next, the item order is incompatible with the technical level of the country to which it is being shipped. The example here is semiconductor manufacturing equipment to a country that has no electronics industry. So this is really going to be dependent on the type of industry you're in. I mean, for a commercial item that is ubiquitous around the world, this isn't going to be a situation you run into because every country can have certain commercial items, if it's clothing or food items, that sort of thing. But if you are in a highly technical industry, then your frontline staff should be trained on and should understand that certain countries in certain parts of the world would not have or need this type of technology. So that's a red flag for diversion. This next one, I find it interesting because this is very situational. If routine installation, training, or maintenance services are declined by the customer, that really depends on who your customer is, what your industry is. If you're selling to a sophisticated buyer or end user, you're likely, they may often reject or decline that sort of training or maintenance because they may be as familiar possibly or more familiar than you are about certain aspects of how it integrates, that sort of thing. In some other situations, though, if you're the only provider of a certain type of technology and you know that generally people are going to need some sort of training and that's refused, well, that's going to raise some question marks. So going through a few more of these, always interesting to me. Delivery dates are vague or deliveries are planned for out-of-the-way destinations. In my experience, I mean, dealing with manufacturers, or if there's components, a lot of the delivery dates are not vague. They're very clear, and if they're missed, then there's problems because it holds up production lines. So I'd be interested to see the legitimate customer that says you can deliver whenever as long as we get it. I mean, again, it'll depend on the type of commodity or service, but that would be interesting. And then deliveries are planned for out-of-the-way destinations. Wherever the delivery address is, you're going to want to screen that and then compare it to the actual business location. Do your research as soon as you get the responses on the in-use statements or your screening hits. This next one, a freight forwarding firm is listed as the product's final destination. That's a big red flag for me because what that generally says is unless you're dealing with an actual freight forwarder and they are the purchaser and end user of some commodity, listing them as the final destination says to me that whoever is responding to me, the purchaser or the end user, doesn't want me to know who the actual final end destination is. So that is absolutely one you're going to want to follow up on. Contact the forwarder. If it is a situation where you're not sure what's going on, definitely contact the forwarder if they're a trustworthy forwarder. Just want to make sure that my slides are progressing. Yes, seems to be the case. Next, if the shipping route is abnormal for the product and destination, that's going. Thank you. Thanks, Robert. If the shipping route is abnormal for the product or destination, this is another situation where you're going to want to communicate with the freight forwarder. If you're not familiar with a normal shipping route, we like to call it the compliance, a community of compliance. So involve these other people if you're unclear, because though it may be uncomfortable if you're not familiar with this forwarder, if say it's a routed transaction, then you're certainly going to want to communicate, because it'd be worse off if you end up with a violation. Packaging is inconsistent with the stated method or shipment destination. That's more communication reviewing. We'll see in one of our enforcement examples, and that should help out. When questioned, the buyer is evasive and especially unclear about whether the purchased product is for domestic use, for export, or for re-export. I mean, if they're evasive, that's always, you're going to need to be skeptical. Sometimes it's just a matter of further communication, but evasive is a word that we use pretty strongly. And if your end user statement, that's a situation where they'll refuse to fill it out, or you get some pushback, you'll need to be skeptical, definitely review further. So that's just a listing of some of the red flags. I wanted to go through those and have an opportunity to talk about them. We'll see these pop up in other situations as we move forward. So know your customer, what does that mean? When we say know your customer, the type of knowledge we're talking about is the knowledge from the regulations, EAR, ITAR, and that doesn't necessarily mean an active, actual knowledge. It could be the circumstances where you should know. That means you should not self-blind. So don't ignore those red flags we just talked about and push through. Also, failing to conduct additional review of unclear or bad facts. This next one is a big one. We'll talk about it a little bit more. Failure to confirm application of OFAC 50% rule. So this especially matters, we've found in exports to Russia or dealings and transactions with Russia, because the structures of the companies there can be really confusing. They can be somewhat evasive and hiding of what's actually structured. So if you are dealing with a Russian entity, especially in certain industries like the energy industry, oil and gas, you definitely want to confirm whether or not that's applying, and not just put the blinders on and go forward and say, I screened it, it didn't pop up, because that's not always, those won't pop up necessarily if they're covered by the 50% rule. They won't pop up when you screen, especially if you're using the consolidated screening list. Some sophisticated software can help get you there, but you definitely need to take the time and really dig into that. So not asking obvious questions triggered by documents that have been received. Here's some advice I'll give to you. Read the documents that you receive, especially new customers, but really all documents, and read through them. We'll see later in an enforcement case, a sales territory included Iran. That should trigger questions. You can't just move forward and say, no, that's fine. If it does something like that, there's a possible relationship with a sanctioned party. When you're screening, you need to screen all parties that are relative to the transaction at all. And if one of those is a possible match, if you say, well, they're not the direct end user, they're not the purchaser, that'll be okay. No, I mean, that's a red flag, and you definitely need to ask questions, follow up, and likely do your own due diligence moving forward. This next one, leveraging end use and end user statements. The regulations are changing so much, especially with regards to certain destination countries. Your end use statement really should have been amended in the past 3, 4, 5 years. It's going to depend, again, on your industry or the regions that you're doing business. But for most people, because of the regulations, especially in the EAR, or if you're doing business in what we call tricky destinations, you should be amending your end user statements. What some of our clients have done or asked us to help them with is having a special end user statement when the destination or the customer is in one of those tricky destinations, namely Russia and China, because those are the tricky destinations where a lot of business is still being done, but that also includes Venezuela and Burma. Figuring out if it's really a civilian or commercial end use, or if there's any military end use capability, You could send an in-use statement, just your general one, and then if you find out the end destination is in one of these destinations, send a second one. It may be frustrating to the customer, but you really want to check all your boxes when it comes to these particular destinations. And to define what I mean by tricky, so there's the obviously embargoed countries, Syria, North Korea, Cuba, and Iran. But then there's these others that are kind of in between, whether there's an arms embargo like China, or there's additional sectoral sanctions like Russia. Those are kind of in between. Thoroughly training sales and other customer-facing staff on export and sanctions compliance. I mean, this is your first line of defense and your first line of offense. They are the ones dealing directly with these people. Sometimes you have an export compliance group that can be really good and really sharp, but then if your customer-facing personnel are not seeing these things immediately, then you can still have a lag, and sometimes those lags can cause problems if someone's out. So thoroughly training all the salespeople, having backup if someone else could be in a customer-facing role, that's really important, something that's often missed if management and export compliance are the only ones getting this training. And then knowing diversion risk, digging a little deeper if, for example, a customer is in the United Arab Emirates, that's a known diversion point, not only necessarily for Iran and sanctioned countries or parties, but also for certain end uses have restrictions, and sometimes the UAE is kind of a jumping off point for things to go anywhere in the region. So I list a lot of the government lists that you should be screening. I'm not going to go into a ton of detail. I will spend a little more time on the OFAC lists. For those that aren't familiar, which most of you likely are, the SDN list, it's basically a blacklist. Even as an attorney, if I were to represent or try to represent an SDN, a listed individual, I would need a special license from the government in order to represent them. So that is a blacklist. It's going to be on all your screening lists, or it certainly should be. But then what's a newer development really started in 2014 after the Russian annexation of Crimea are the sectoral sanctions identifications list. So these are dealing with specific sectors of the Russian economy, the energy sector, finance, and defense and material sectors. And it's really only prohibiting certain types of transactions. So those actually, if it's an SDN, it's really an easier question most times. There's less due diligence that needs to be conducted because you can't do business with them. I mean, you can try and get a license, you're likely not going to. But the SSI, you really have to dig in, and that's a more difficult question, whether or not it's one of the SSI listed entities, which directive they're listed under, and also what the specific transaction looks like and whether or not that's prohibited. And like I mentioned briefly earlier, entries on the SDN list and SSI list, both of them, I mean, most people know about the SDN list, but the SSI list are also subject to the 50% rule. So if an entity is 50% more owned directly or indirectly in the aggregate, which all those are important qualifiers by an SDN or SSI listed entity, then the same restrictions that apply to the listed entities are going to apply to the company that's 50%, or that's subject to the 50% rule. DDTC list, these are going to pop up if there's a debarred party and it's on the debarred parties list, you're not able to transact with them when it comes to technical data or defense services, or of course defense articles that are subject to the ITAR. BIS list, don't want to spend a lot of time on this either, except for 2 points. So one is most of these lists they're not like the SDN list. This isn't a blacklist. If you're screening and the unverified list comes up, well, that's not the end of the story. In a lot of cases, it just means you can't use a license exception, or for the entity list, unless there's a policy of denial, you'll need to get or apply for a license. So there may still be a way through, unlike the SDN list. The other point I wanted to make is about the newer military end user list. So this only applies at present to Burma, more very recently, Burma again after the coup, China, Russia, and Venezuela. I did want to point out at this time, there's no Venezuelan companies that are currently listed on the MEU, but because they are subject to this portion of the EAR, that could happen at any point. And this is all came about within the last 12 or 13, 14 months. And I did want to make another comment because the government likes to use terminology that can be pretty similar. So there's the military end user list, but also in the past several months, there's restrictions related to military intelligence end users. That's a separate list. It applies to those tricky destinations, Burma, China, Russia, Venezuela, as well as the embargoed countries of Iran, Cuba, Syria, North Korea. The intelligence agencies of those countries are all military intelligence end users, and so anything subject to the EAR is going to require a license, and good luck getting it there. But very similar, but those are actually different concepts that need to be drilled down into. Most people won't be exporting to those intelligence agencies, but the military end user list, especially when it comes to China, is going to include some companies that are not, you wouldn't think of as military companies, just because there's such an integration between commercial and military operations in China. Not going to spend any time here, just you will get the slides, but these are just a small handful of non-US lists that, depending on where you're doing businesses, may affect you. For screening, so there's the common consolidated screening list. This is free. It's updated every day. Startups and certain other companies may use these. More sophisticated companies have often moved on from the consolidated screening list, but if you're new to screening and don't have the software, I mean, this is a good way to search. It's got all the lists that I just talked about, or at least the US list, and it'll have some other ones too. Third-party software, this is what most established sophisticated companies are dealing with. There's all sorts of companies that are doing this. They can integrate with an ERP system. There's sometimes functions that can block transactions within the ERP system. Really the key here is to know what you're getting, what you have, what searches are conducted. Does it do a fuzzy term search, which is quite important, and how configurable it is, and you may need to adjust that. I mean, there's a good chance you will if there is an escape, of course. Sometimes you wouldn't necessarily notice that it needs to be updated, but someone familiar should be in charge of setting the different things that can be provided. Okay, so this is not typically in a due diligence presentation, or not many that I've seen, because it's kind of different than your regular exports, but I definitely wanted to mention this just because we see it a lot, and I'm still not sure that the word is out as much as it should be about deemed exports. So for those that are unfamiliar, if controlled technology or technical data is released to a foreign national in the United States, then the U.S. government deems that to be an export to the foreign national's home country. So if there's an engineer from Singapore that's in the U.S. on a visa, and the U.S. company releases certain drawings, controlled drawings, 600 series, something like that, to the Singapore national, that's a deemed export. And if a license was required and it wasn't obtained, then there's a violation there, an export violation. Even though the whole release occurred in the territory of the U.S., the government deems that to be an export. So the due diligence here, one, make sure HR in the hiring process is coordinating with export and sanctions compliance during the hiring process. Nationalities are known. Make sure your HR department knows what a U.S. person is under the export regulations, so citizens, green card holders, and a small class of other individuals like asylees, but really specific if it's not a green card or U.S. citizen. So people here on visas, that's not a U.S. person. A temporary protected status, which we've seen on more than one occasion, there's confusion there. That's not a U.S. person. So just make sure if a license is necessary, you get it prior to releasing any controlled data. That's all I'm saying on deemed exports, but I do feel strongly that this needs to be part of a due diligence program. Record keeping, it's 5 years after the export, generally speaking, and so if there's an in-use statement, if there's screening results, include that in the file with all the shipping paperwork. And of course, if you're not already doing it, you should be keeping all the shipping documentation for 5 years after the export. A lot of those third-party screening platforms that we talked about can automatically document it. If you're using the consolidated screening list, you'll have to manually do it. Take a screenshot and you can save that in the file. So going quickly here, because I want to leave some time for questions, but I do have a couple of cases, or I guess 3 cases. These 2 are linked. And this one's very recent. This is an OFAC settlement. It's for $200,000 or $216,000 and some change. Ohio manufacturer that manufactured process controls, pressure switches, other instrumentation. I like to call this where there's smoke, there's fire case, because specifically OFAC discussed warning signs that the Ohio U.S. company ignored. And when you read the whole thing, I just have bullet points here, but you can really tell something weird is going on. So it started when this European customer, as they're referred to in the OFAC documents, they initially just mentioned openness to dealing with Iran. That should have ended it right there, stopping things at that point. But that didn't happen. And then there were several other instances. Request to remove Made in USA label. That's always going to trigger additional questions, obviously from the sanctions or export component. But for me, as soon as they say that, I know that all these other countries have country of origin and marking rules. So even beyond if it's going to a sanctioned destination or anything about licensing required, removing a country of origin marking or label, I mean, that's a big no-no just about everywhere in the world. So that's the first one. Like I mentioned earlier, in this particular case, the European customer in a sales agreement or sales representation type agreement, Iran was included in that sales territory. That should certainly have been followed up on, and even then, combined with everything else, at that point you may want to get out of this just because you know you're possibly dealing with a sanctioned country. I'm going to skip this third bullet point really quickly and come back to it. The fourth one, at a European trade show, there were Iranian nationals that were at this European customer's booth, and representatives from the Ohio company saw this, and I believe in the documents interacted with them some, or at least knew enough that they are Iranian, and they were at the trade show looking at products from this U.S. company. So they're looking at it likely for a reason. And then the third bullet point that I skipped a second ago, this one's interesting. OFAC cited this specifically. So the Ohio company, Unicontrol, there were a bunch of delays due to the European customer. Unicontrol offered, because of these delays, to ship directly to the end user, but the European customer, kind of the middleman, rejected that offer. OFAC pointed that out, and in certain situations I can understand that, but also understanding that the middleman is going to have a markup. It's going to be rare situations where they'll often say, go ahead and ship to the final end user if that's not how the relationship is established. So I took a little bit more issue with the third bullet point, but these other ones, where there's smoke, there's fire. And to round this out, a few days after the Unicontrol settlement, the Nordigas settlement came out 11 days later. Just wanted to include this because they also had to settle with OFAC. They're the European customer that's referenced in the Unicontrol settlement. In Unicontrol, they never mentioned a name, but based on having the exact same warning signs and situation, you can pretty confidently decide that that's the European customer. It was an Italian company. So The Cobham settlement, this was from a few years ago, but when it comes to screening, this is kind of a nightmare scenario. It was an $87,000 settlement. Basically, two things happened here, and they're both related to screening. So screening had occurred when they originally screened, or when they originally entered into the relationship, or before a full transaction, they screened and the end user did not come up. 2 weeks later, when they actually shipped, the end user had already been listed on the SDN. So had they screened right before shipment, then they should have caught that. But they only did at the initial time of engagement. That's a recommendation for us. We get asked this a lot. So when should we screen? Some of these third-party services will allow you to screen every day. And if you can set that up, absolutely, because situations like this can come up. But definitely when the relationship is started, anytime there's a transaction, and then right before shipping is usually what we recommend as best practice if you can't do it more frequently, if you're having to do it manually or something. And then in just a perfect storm of screening issues, another situation discussed in this settlement is Cobham's software did not identify the blocked party based on what they entered, even though it was very similar. So they searched for Almaz Ante Telecom or Almaz Ante, and it did not pull up Almaz Ante Telecom. So only one word difference, and it's not even the important part of the name. So that's really something you want to upgrade, and eventually Cobham did as part of their mitigating actions was to update their screening software just to make sure it's going to have the fuzzy search that would catch something that's this close. But you have to really make sure and run tests. I mean, that's one way to do it, to make sure your software is covering what it needs to be covering. Penalties, not much to say here, except there are a lot. ITAR is nearly 1.2 million for civil violations. EAR over 300,000. Same with most OFAC violations. It depends on which statute the OFAC regulations are under, but it can be up to 300,000 per violation. Those are all civil. Criminal is if knowledge is involved, in hopefully there's not bad actors here that need to know that, because criminal's only going to be brought up when there's knowledge that violations are occurring, but otherwise it's civil and it's strict liability. So I've gone over what I wanted to. I won't cover these in any detail. This is just BIS's compliance program recommendations, very similar to what you'd see under DDTC or OFAC. And then I included just some notes about, for each of these sections, what you would expect for your screening due diligence program and how it fits into the entire compliance program. Not going to cover this, but you will get the slides so you can peruse these at your own leisure. So a last few tips and final thoughts, and I've talked about some of these throughout. One thing that's great to do for sanctions specifically is subscribe to the OFAC alerts. I provided the link there. For those of you that are already subscribed, or when you do, if you haven't yet, you'll see how active this is. It feels like every day there's an addition or a removal. I mean, things are really active when it comes to the OFAC list, because it just covers, it's not just the embargoed countries. There's sanctions lists that cover all sorts of things: drug kingpins, terrorism, all the human trafficking, and this covers all the lists. And so it's going to get added on there, and you'll get an email alert, and you can just quickly glance at it, see, oh, this involves some country we don't do any business, it doesn't affect us. Or if something new, a new SSI listing for Russia, and you do business in Russia, then you're going to want to drill down and see what's going on, see if it affects you, see if you need to modify anything you're doing. Restatement of something I said before, because I think this is a good idea for those tricky destinations, is having a particular end-use statement if it's going to those. So if I have a lot of business in China, then I'll probably add something clarifying this isn't going to any military end users, possibly adding the EAR definition of what a military end user is, because is not necessarily intuitive. That sort of thing. In Russia, if I'm in particular industries, just making sure it's not going to hit any of those SSI prohibited transactions. Beware of red flags. I think I spent plenty of time on that earlier, hopefully not too much. I thought that was good exercise. The next bullet point, self-reliance, and this is something we see. People are under the impression, whether rightfully so or not, based on contract, that they're forwarders or some other party is going to conduct the due diligence. That's generally not going to be the case. Sometimes that can be included in a contract, but even then, if it's my company, I still trust myself more than any other party. I trust my company to train its staff to know what's going on. So try to outsource that as little as possible. And for the most case, you can't at all, because you're the exporter and you're going to be subject to any penalties likely. So rely on yourself when it comes to due diligence. One more slide of these. False positive adjudication is key. There's been other OFAC, particularly settlements, and it's based on screening. And there's been what someone in the company may think is a false positive, but it turns out to be an actual positive, but something gets cleared as a false positive, and it turns out that no, it was rightfully flagged. So make sure there's training where everyone knows when to escalate, when to investigate, and when to actually clear a transaction. Importantly, a written compliance program. You want to formalize these processes and then train on them, of course. This next, the third bullet point, may be the most interesting and honestly sometimes fun part of due diligence. It's when you're actually doing what you should be doing when you have questions. You check the actual physical address. It's Google Maps, use that. That's your friend. Check the website. Do they have a website? Does it seem like a legitimate business? Do they have an actual email case? Do they have an actual email domain name, or is it a Gmail or a Yahoo, something like that? Continue to check through that, and sometimes you go down rabbit holes, and sometimes those rabbit holes lead to a discovery that this is not someone that you should be doing business with. So it may take some time on the front end, but that's going to be better than if you get caught in a violation because you did not really dig into these possibly suspicious companies. Again, training, refresher training, things are changing all the time. Obviously, new hires need to know that's part of the culture of compliance, and then keeping everyone up to date. Run through scenarios. If you're experienced in this, then share your knowledge with people that may be working under you as far as what you've experienced, if something has been suspicious and anything you found that way. If you don't have a lot of scenarios, you can look through the OFAC and other agency charging letters and settlement documents just to see what's happening, like the unit control case. It gave the warning signs and also the red flags if you want to work through those. I think that's it. I'm going to look to see if there's any questions for the last few minutes of this. Let's see. Yes, we will be getting the slides, and we're also going to send out the due diligence checklist that we promised. Any other questions? Okay, as far as, can you please provide an example of plain language general end user statement for exporters of EAR 99 products that the destination triggers a red flag? So in just if the product only relates to something that's completely commercial, it's EAR 99, but the destination, usually we'd want to see some statement about sanctions, because that could not matter if it's EAR 99. It could just be, you can't send it to Iran. So we want to see a statement about sanctions, that it wouldn't end up or be re-exported to a sanctioned destination. As far as the destination triggers a red flag, I I'd be curious. I'd kind of have to see what that actually looks like, whether it's the end user that's triggering the red flag, or if it's the country of destination that triggers a red flag, and why it's triggering that red flag. So it sounds like if there's a red flag, then maybe it's not a general end user statement at that point. Maybe that's you need to follow up further if there's a red flag triggered. Okay, so I have a long question here. Work for a government research institution and we struggle with verification and record keeping. For example, we have an alert in our screening software on a researcher with the same name. We need to see passport or other form of government ID to ensure it's not the same person. However, we are prohibited from storing personally identifiable information such as passports, social security number. What would you suggest as a method of record keeping? Okay, I would be interested to know. It sounds kind of like GDPR, which I'm not well versed in since we don't have it here in the US. Our customers or our clients dealing with this sort of verification will often be able to request government ID. So it is like a GDPR issue. I'm not exactly sure of how to handle the balancing act, although I appreciate that it's difficult between checking against the screening list and also storing personal identifiable information. That's company policy, or I guess government. Yeah, I mean, I would actually have to see how that's broken down, but that usually shouldn't be an issue to verify someone's identity. I mean, that's required for licensing, you know, to prove someone's a U.S. person, at least here in the United States. Those are all the questions that I've gotten, at least that I see for now. Well, one more. I don't want to hold y'all too long. Can you give an example of what needs to be modified for end user statement China, Russia? So one thing in the EAR 15 CFR 744.21, that's the military end use and military end user restrictions. So that applies to China, Russia, Burma, and Venezuela. Like I said, China and Russia are more the big ticket countries. A lot of business is still being done there. Depending on your industry, and possibly even not, because this is not just military items that are being sent there. In fact, already you're going to have issues with those. But for non-military items, there's a list of those items. So you can either reference that list, or you should know your classification. So you'll know if you're on that list. But then you'll want to disclaim and determine whether or not the end user is one of these military end users. And so what we have done in the past is include a definition. So that's a statement, I certify that such and such company, or my company that I represent, however the language works, is not a military end user as defined by 15 CFR 744.21. But then also it's important to include that definition. I mean, it's at that point, it's no longer a short and sweet end use statement, but when you're doing business in China or Russia right now, we're kind of past having the short and sweet one pager because you're going to want to include everything. So for China and Russia, you'd have a statement about whether or not they're a military end user. You want them to certify that. And like for Russia, depending on the industry, if you're oil and gas industry, energy, something like that, there's specific prohibited transactions that are listed based on whichever directive it falls under on the sectoral sanctions. And you would want to, if I'm doing oil, I would want to say this is not for, I certify this is not for deep water, offshore, Arctic. There's specific types of transactions that are prohibited. You would want to specifically include those, and we've seen that from customers. And I think these end users and customers in those countries are definitely starting to get used to that because a lot of the U.S. companies are putting that in there. Okay, well, if nothing else, that's all the questions I'm seeing. And I think I'd like to thank everyone for attending today. If you have any other questions, you can contact me. My email should be up here at the bottom. Make sure everyone sees that. As a reminder, we have 3 upcoming webinars, the Torres webinar series. Next webinar will be on managing complex corporate investigations involving trade matters. That's September 15th. For more information, you can contact us at operation@torrestradelawcom. Again, thanks all for joining. Have a great rest of your day.